Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we are talking about the fourth exception to the doctrine of privity of contract. The first exception we talked about was that of the law of agency. The second exception is that of covenant running with land. The third exception is the sale of family land in customary law. And the fourth exception, which we are discussing today, is known as collateral contract. Collateral contract. We've discussed the doctrine of privity of contract in details in previous sets of classes, but in this particular class we would be talking about collateral contract. If you have not watched those previous classes, kindly go to my channel and kindly click the contract law playlist and you will see the previous set of classes, and I advise that you watch those classes before you continue with this particular one. But for those who are abreast with the information in the previous classes, those who have watched the previous classes, then it's time for us to go to our fourth exception of the doctrine of privity of contract. But before we go straight into what we have for today, if this is your first time of coming to my channel, then I want to say a very big welcome. Thank you so much for coming to my channel. Don't forget to click the subscribe button and click the notification bell so that anytime I release a video of this nature which is going to be of interest to you, you will be one of the first set of people to watch that particular video. Also, do not forget to share with your friends and colleagues and those people that you know are going to benefit a lot from the lecture. Lastly, do not forget to follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. Thank you so much as you do so. So now, going straight to what we have today, we are talking about collateral contract. Now, going to our notes, a collateral contract is one that accompanies the main contract between two parties. It is one involving either of them and a third party. At this point, you'll be wondering, okay, I still do not understand what we are talking about. Yes, let's read through this case. I will use the case to explain the principle of collateral contract being an exception to the doctrine of privity. So what is the name of this case in question? The case is Shanklin Pier Limited versus Detel Product Limited, 1951 case. Shanklin Pier Limited versus Detel Product Limited. So what's the fact of the case? The plaintiffs were owner of a pier in Shanklin on the Isle of Wight. So let us say that this pier in question is a bridge. I don't want to go into details of what a pier is and all that, but let us say that it is a bridge. Now, the plaintiffs were the owners of what? A bridge, right? So what happened? They entered into a contract with contractors to have the pier repaired and painted. So you know what the plaintiff said? Let us paint and renovate, that's repair this particular bridge. And then the plaintiff, who are the plaintiff there? Shanklin Piers Limited, Abi. They now had a contract with who? With contractors, not the defendant, with contractors. They told the contractors that they wanted to repair and paint the bridge. Now, under the contract, the plaintiff had the express right to alter the contract. Okay, there's no problem with that. As a term of the contract, is stated there that the plaintiff can alter the contract before completion, and I don't think that should be a problem. Now, the defendant company director approached the plaintiff with a new painting product for the pier. So when they heard that the plaintiff want to paint and repair this bridge in question, the defendant, who obviously sells paint, the defendant, a paint seller, now went to go and meet the plaintiff. And what did he tell the plaintiff? He told the plaintiff, we have a new paint, very good paint, you will love the paint, and all that and all that. And what did the plaintiff do after the market of the paint? After much persuasion, the plaintiff amended their contract with the contractors to allow for the paint in the renovation. After several months, the paint flaked off and did not last. Then the plaintiff brought claim for damages. Now, you should know that the plaintiff brought claim for damages under the contract with the contractors and not under the contract with the paint sellers. I don't want you to get that confused. Now, you know that, to me, I want you to picture this as there are two contracts. Just listen to me. Now, we have one contract with the contractors, right? The plaintiff and the contractors. P and C. P for plaintiff, C for contractors. Now, what was the subject matter of that contract? The subject matter of the contract is for what? Is for there to be a reparation and painting of what? Of the bridge. Okay? Now, there is another contract, so to say, but listen to me. The contract now is between plaintiff and the defendant. Who is the defendant? The defendant is the paint sellers. Now, that's what? P and D. You know, the first one is plaintiff and contractors, P and C. Now, the one with the defendant has to do with selling of paints. So now I want you to look at something. I want you to understand that when the plaintiff bought the paint and he did all of that, there was no point in that contract where they talked about express damage. Are you listening to me? Now I want you to understand that the plaintiff brought that contract and incorporated it into the one with the contractors. How did he incorporate it? He altered the one with the contractors and forced the contractors to what? To then use that paint in painting the bridges, which the contractors did not want to. So he had to alter his what? His contract to impute that particular term that the contractors should what? Should use the defendant's paint. That's the paint sellers. So the question then is, why are you suing the defendant under the contract with the contractors? So let us look at the issue. Whether the plaintiff was entitled to bring a claim against the defendant company who was not a party to the contract to undertake renovations. Now, what is the court judgment? The defendant was found to be liable given he had provided an express warranty over the paint to the plaintiff, who in consideration of the warranty caused the contractors to buy the paint from the defendant also and suffer the same damage by reason of a breach of warranty. It was held that if the contractors for the direct sale and purchase had been made between the plaintiff and the defendant with no involvement of a contractor, then the same warranty for the same paint will be intended to exist and be implied. The judge saw no reason as to why the same warranty should not be enforceable and extend between the plaintiff and the defendant. The plaintiff was entitled to recover damages. So this is the Latin I will just learn now. This is what we are saying. We are saying that we have a plaintiff, I already explained that to you, who made a contract with the defendant, and the plaintiff also made another contract with the paint sellers. I am very sure that the reason the plaintiff went with that of the contractors, that's the contract with the contractors, is because there must have been an express clause that entitled them to more damages than they would have had if they had sued based on the contract that they had with the defendants. Now, listen to what I'm trying to say. Listen to this logic. This is what I'm saying. Now, you know that there are two contracts, like I explained earlier, right? P and C, plaintiff and contractors. So, imagine that it was stated there in the contract that where there is a breach of warranty whatsoever, the party who causes the breach of that warranty would pay the other party 100 million. Now, note that when they were buying the paint from the defendant, listen to me, when they were buying the paint from the defendant, note that they did not, because the question will be, why don't you just sue the defendant directly and you can still collect the money? Why are you coming under collateral contract? Since you already had a contract with the defendant, that's the paint sellers, Coco, collect your money directly from them. That's the sensible thing that any lawyer would have asked, right? But that contract that they had with the paint sellers, there was no express term that would have entitled them to more damages. Do you understand? So even if the court were to award them damages, maybe the court would just say, okay, give them 5 million. But don't forget that in the other contract with the contractors, where there is a breach of warranty, it has been stated there that it's going to be what? Is going to be 100 million. So what did the lawyer say? The lawyer said, because this is a collateral contract, do you understand? Then it falls into the main contract. It's a collateral contract because it was made by virtue of the main contract. If we've not had the contract with the contractors, we would not have had the contract with the painters. Do you understand? Because there has been a contract with the contractors, we then have a contract with the painters. So that means it is collateral. Do you understand? Let me give you another example of how collateral works. Imagine that we have boyfriend and we have girlfriend, right? Are you following me? Now, and then the boyfriend wants to carry the girlfriend out, yeah? And then the girlfriend say, I don't know this boy so well, oh. Let me call one of my friends. Are you listening to me? If not because the boy wants to carry the girlfriend out, there would not be a need for that third party to be there. Are you following that? Because we are going to a restaurant and the girl is not so sure of this guy, she now carried one of her friends and said, hey, please follow me to the restaurant. The boyfriend would not have had any contact with that third party, that girl that is coming as a third party, if not because of the girlfriend herself. Therefore, this plaintiff would not have had any business with who? With the third party, that is the paint sellers, if not because of the contract that they had with the contractors. Therefore, any contract that they had with the paint sellers is therefore a collateral contract in the main contract with the contractors. It came by virtue of the main contract with the contractors. But for the contract with the contractors, there wouldn't be another contract of sale of paint to the plaintiff. Right? So it was because of this one that they now altered the contract to include the paint. Therefore, it becomes a collateral contract with the main contract with the contractors. And what does that mean? It means that the plaintiff can sue the defendant based on the main contract with the contractors. Do you understand? That is how it now becomes an exception to the doctrine of privity. Are you listening to me? This is what makes it an exception. So I gave you the motive behind it, because there is a contract with the defendant, right? There is sale of paint, Abi, between one party and another party. Now, if there has been a sale of paint, why don't you just sue him based on the contract of paint, right? I buy paint from you and the paint no last, give me my money. And I've given you an idea that one of the reasons why they could have done that is because maybe in that contract with the defendant, that's the paint sellers, there was no express warranty that if anything happens and you breach this contract, you are going to pay so amount for breach. But in the main contract, which is the one with the contractors, there is an expressly stated term that if you breach this contract, you must pay this so money. So therefore, when a party is now sued based on that, existing contract with the contractors, if that party breaches, that party must pay the damage according to the contract. Are you listening? Do you see the motive? Because if the damage according to the contract with the contractors is what? Is 100 million, and the damage according to the other one, which there was no express term, is 5 million. You as a lawyer, what will you do? You will try to get the 100 million. So you will then begin to look for ways to argue. How can we bring this person into this main contract? And how do you do that? You bring the person into the main contract by saying that the contract is a collateral contract to this contract, and therefore the person can be sued under the main contract. Since the collateral contract came up by virtue of that main contract, therefore the person can be sued under the main contract. Do you understand that? I think I've given a very detailed explanation. when you are talking about collateral contract, what is that key thing you should be looking for? Did the collateral contract come up by virtue of the main contract? Did that third party during the date come up by virtue of the girlfriend? Or is it that whether or not that girlfriend was there, that third party will still come to that same restaurant to come and meet the boy? If that is the case, then that third party cannot be said to be what? Collateral contract. So when you come to this matter that we are talking about, when you are talking about a collateral contract, if we can say that the plaintiff would have an agreement with the paint sellers regardless of the fact that they had, you know, a main contract, they will still have had an agreement with then you cannot say that that's a collateral contract. Collateral contract is by virtue of the main contract. It is because of this main contract. If we didn't have this main contract, then there wouldn't have been this other contract, which is now the collateral contract. It is because we have this main contract that we then need the collateral contract. Do you understand what I'm saying? So can you see how collateral contract and main contract work? So yes, that is what we are talking about. And so if done properly, collateral contract can be an exception to the doctrine of privity of contract. And that is where we end our class for today. In our next class, we'll be talking about contract for the hire of a chattel. Contract for the hire of a chattel as an exception to the doctrine of privity of contract. I hope that you understand the nitty-gritty of this class. Thank you so much for watching to the end. Please don't forget to share with your friends and those people that you know will be interested by this, and don't forget to subscribe and like. Follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. I will see you in my next class.